Welcome to another week and another few key documents. This time we'll be examining the Constitution, the Federalists, and the Anti-Federalists. By way of reminder, we said that the Declaration of Independence functions on a practical level as the main ideal for the United States. In a perfect world, this is what we want the United States to accomplish. The constitutions we've written started with the Articles of Confederation, were America's attempts to meet that ideal. The problem was, though, the Articles of Confederation simply didn't work. Government is like fire in that it is essential to human life. You needed it to stay warm, cook food, make things, etc., etc., but fire is extremely dangerous when it gets out of hand. If you had been burned by fire, you might be tempted to put up so many layers of protection around it that it would defeat the purpose of having it at all. If you build it in a brick box so thick that you can't feel any of the heat, what's the point? That's sort of what happened with the Articles of Confederation. The Founding Fathers had been burned by British tyranny. So, when they built the Articles, they built in so many protections against any and all possible tyranny that the government was so weak it simply couldn't do its job. Clearly it was time to start over, and the Constitutional Convention in Philadelphia did just that in 1787. Today we'll take a closer look at what they accomplished. The biggest problem most people have today with understanding the Constitution is the fact that, frankly, many of us have forgotten how to read. Or maybe I should say what it means to read and what the point is. Of course, most people can process words and pronounce them in their head or out loud, but what do you hope to get from reading them? And what do you do with them when you've read them? That's another issue entirely. From the time we're children, many schools shovel drivel into our heads that says everything in this world is just opinion, and that includes reading and writing. Therefore, when we read something, we should be more concerned with how it makes us feel than what the writing actually says. A good example of this is all of the personal reaction essays that many students write going through school. Essays like that aren't there to teach you to determine truth from lies, or whether or not you even understand what the author is saying, but rather they show you how to see your opinion in what the author had to say, to press your ideas onto what you're reading rather than learn something from what you're reading. As you progress further in your education, especially at the average high school, college, or university, they begin to tell you that language in books really communicate nothing at all. As a reader, you simply interpret the words as you like them, and you take them to mean what you think they should. The original author and his or her meaning is often completely forgotten. It's all about me and what I think and what I want. The common theme in all of this is simple. The words on the page don't matter, they mean nothing, or both at once. If that is true, we give up looking for the truth of what an author has to say and instead focus on reading into it what we want to see. This, of course, is complete bosh. These people are giving lectures and writing books about how language communicates nothing. Anyone so frankly ignorantly hypocritical should sit down and be quiet. Obviously, if these people expect you to read their words and walk away knowing what those words meant, they have no business telling you that words mean nothing and that authors don't matter. It may be nonsense, but it is extremely popular and influential nonsense, and it has taken over many colleges and universities. Those colleges and universities are producing most of the teachers and administrators who have been running high schools for the last 30 years. So to say that this kind of thinking is widespread is an understatement. Today, thousands of politicians and activists look to the Constitution not to find out what the founders meant by it, but rather to see how they can read their own agendas into it. Some are even beginning to be a bit more honest, and they're starting to talk about getting rid of the Constitution altogether. Now, Whatever else we might get wrong in this class, I have no intention of committing this particular intellectual sin. It's best that we understand what is really at stake here and do what we have to do to step back, grant the founders really could say something significant in the Constitution, and find out what it is. All right, so first let's clear up a few things that the Constitution is not. It is not the product of Thomas Jefferson. Many people think that since Jefferson wrote the Declaration, he must also have written the Constitution. Some people confuse the Constitution with the Declaration, but they're two obviously separate documents. People often say this is a way of quote-unquote proving that the U.S. was founded as a secular nation. As we've mentioned, Jefferson was a deist, and so they reason that the documents he wrote must be deistic too. This is simply not true. Jefferson wasn't even in the country when the Constitution was written. It was composed by the combined efforts of those in attendance, many of whom already had experience creating their own state governments. Next, it was not an easy thing to accomplish. The convention aimed to significantly increase the power of the central or federal government without giving it a chance to turn tyrannical. Finding the balance between state and federal power, between too many checks and balances and not enough, was very delicate work. Remember that this wasn't the U.S.'s first try, and its previous attempt had failed. So the feat these men accomplished in creating the document they did was quite notable. Next, it's not simply the Bill of Rights. People often make the mistake of thinking that the Bill of Rights contains everything that's important in the Constitution. Not so. The Bill of Rights is important, and we'll talk about it, but it's only part of the story. The problem, or so the founders thought, was that you can't list every little right so defined in the Constitution. Should I have to write down that the government can't force you to use a certain kind of toothpaste, for example? The bulk of the Constitution is intended to place specific limitations on the government so that it won't be able to trample your broader rights. Then the Bill of Rights calls out a few of those rights to make them extra clear because they think them extra important. Next, the Constitution is not a flexible document. For decades now, school teachers, well-meaning though they may be, have liked to regale us with the tale that the genius of the Constitution is in how flexible it is, how it keeps stretching and morphing as time passes. This would have made the founders want to strangle somebody. The whole idea of the Constitution was that it doesn't change. The founders didn't want your rights to be taken away just because somebody had a new idea or changed their minds. Therefore, they wrote it all down in the Constitution and made it hard to change on purpose. You can change the Constitution, but the process is long and difficult. Perhaps that's why people today just ignore the process. And finally, the Constitution is not an atheistic or deistic document. Of the 55 members of the Constitutional Convention, 52 were active members of their church. None that we know of were atheist. One of the very few avowed deists, Benjamin Franklin, even asked for prayer at the meetings, which is a very undeistic thing to do. The Constitution even opens with, "In the year of our Lord," something you wouldn't expect if it were intended to be a purely non-religious work. So while the document was intended to respect the faith of both believers and non-believers alike, it likewise was not intended to take anything away from religion or to place undue restrictions upon its public profession. On the other hand, the Constitution is a direct attempt to fulfill the ideals of the Declaration. It is America's best attempt to protect the life and liberty of its people and their ability to pursue what makes them happy by placing clear, specific limitations on what the government can do. It does this by, in theory, spelling out in writing those specific powers that the government is supposed to have. These powers and rights aren't up for debate or interpretation. They're all there on the page for anyone to read. That is an important point. The Constitution wasn't intended to enable the government to do anything it wanted. Rather, it was there to empower it to do certain things and then limit it in every other respect. Perhaps more importantly, it was to do so through the written word. While the convention didn't go overboard with the flowery religious language, the Constitution is based on a Christian worldview, and it requires Christian presuppositions and ideas to function properly. There are two basic points that must be true in order for the Constitution to work as it was intended. Both of these flow out of America's Reformation background. First, we assume that humanity is capable of governing itself. Well, that seems like a no-brainer, but it hasn't always been so obvious. Many cultures said it was impossible, and so it can't be taken for granted. Second, we must believe that humanity is born with an inherent bent towards evil for the Constitution to make sense. Why? Because the Constitution is so filled with checks and balances that get in the way of doing things that if we stick to them, governing is positively inconvenient. Why would anyone create a government that made it harder to get things done than would otherwise be the case? For the simple reason that they knew that with humanity's bent towards evil and taking that as a given, it won't be a question if someone tries to seize control and tyrannize the people, but a question of when and who. As such, they wanted to put as many roadblocks in the way of would-be tyrants as possible, but still allow the government to do its job. As we look at these ideas, we must grant that the first one isn't exclusively Christian. The Enlightenment and even atheism believes that too. The second one, however, was born in a strong Reformation worldview that emphasizes the literal fall of Adam and Eve. The idea of inherent human evil was explicitly rejected by the Enlightenment, deists and atheists alike, as seen in the bloodbath that was the French Revolution. Further, as America has fallen farther and farther away from her Christian roots, one of the first things to go were the checks and balances. If you don't believe that humans are inherently evil, who needs checks and balances? It shouldn't be surprising then that the further we fall, the more checks and balances seem to be cut out. Finally, the Constitution is your tool to defend your freedom. It is intended to give you every chance to prevent an erosion of your rights. It's like a lock on a door. It makes it difficult for the bad guy to get in and get you. Difficult, but not impossible. If you lock your door and then you ignore it, you go to sleep, you pay no attention to it, if someone wants in, they'll find a way. They'll pick the lock, they'll knock the door in, they'll break a window. So is having a lock on your door pointless? Certainly not. If you're watching and waiting and being aware of what's happening, the lock on the door will slow the bad guys down enough for you to do something about it, to defend yourself. In the same way, if people ignore the government, there's nothing magical about the Constitution that makes it tyranny-proof. But if you're ready and willing and paying attention, you can use it to defend your rights. It gives you every chance to do so. Therefore, virtually every level or turn of phrase in the Constitution seems to be some kind of check and balance on another. You're most likely familiar with the separation of powers, elections, and the like, but it goes much deeper than that. For example, originally the House of Representatives was elected by the common people, but members of the Senate were appointed directly by the state governments. Why? Isn't that anti-democratic? Because the founders wanted to play the common men and women off against the elites. They didn't think that either side, common or elite, could be fully trusted. So they set up Congress to force both sides to work together and to keep each other in check. As you read, keep an eye out for others you might come across. Once again, though, the proverbial elephant in the room is still the issue of slavery. If the Constitution is an attempt to meet the ideals of the Declaration, what do we do with slavery? I wish I could say that the founders took advantage of this chance to set things right. Unfortunately, they did not, and the Constitution is as deeply enmeshed in the dilemma of the Declaration as any other part of American history before the Civil War. That might seem shocking to some of us, as we've been raised to almost idolize this document. The truth is, though, that the Constitution was written by fallible, fallen men, and the failure to deal with slavery represents one of their greatest errors. They were, however, acutely aware of the obvious contradiction. In fact, they were so sensitive to the subject and embarrassed by it that they refused to even use the word slave in the document. In the Three-Fifths Compromise, for example, they referred to persons bound to servitude, rather than just come out and say slavery. The reason for this is simple. The founders, North and South alike, knew that slavery was evil, but they were too afraid of what might happen if they just freed all the slaves at once. The economic loss to the South would be devastating. Further, if they just let all the slaves go without any help or education, it would be almost as good as a death sentence. How would the freed slaves feed their families or take care of themselves? As a result, the founders wanted to end slavery slowly by gradually emancipating slaves over time. That would allow America to accomplish the same goal without doing nearly as much damage to all involved. That sounds great on paper, but as we know, there was a catch. It didn't happen. Worse, the longer slavery was allowed to survive, the more painful its eventual destruction would become. Like a cancer, the operation will hurt regardless, but the longer the cancer is allowed to grow, the deeper the surgeon will have to cut to get it all out. So with the benefit of hindsight, we can say that the founders missed what was perhaps the best opportunity to kill slavery with the least amount of pain when they shrank back from doing the hard thing here. America and Americans are still paying for that decision. Now, also with the benefit of hindsight, the question of would it pass seems like a no-brainer. Of course it's going to pass. After all, it's one of the greatest governing documents in human history. You have to be crazy not to want to pass the Constitution, right? Well, remember at the time, it was just the next in what looked like could have become a series of attempts to come up with a working document. How could you know that the second time was the charm and not the third, or fourth, or fifth, etc.? Also, as great as the Constitution is, as we mentioned, it's still a human document, and any human document will have its shortcomings. Smaller states like Rhode Island actually liked the Articles of Confederation. Since the Articles required a unanimous vote to make any changes to it, it gave states like Rhode Island and New Jersey and tiny little Georgia incredible power over the others. The idea of giving that up worried them considerably, and more than a few Americans were still nervous about creating a government with this much power. And so the debates began, with 2/3 of the state legislatures needing to ratify the Constitution before it would go into effect. Those in favor of the Constitution, including Alexander Hamilton, James Madison, and John Jay, were called the Federalists because they were in favor of the federal government, which was the name for the new, more powerful grouping of states. On the other hand, those who were worried about it and opposed it were called Anti-Federalists. Prominent Anti-Federalists included Patrick Henry, George Mason, Richard Henry Lee, and Samuel Adams. Each side came at the other with their strongest arguments via essays published in various newspapers that had readers all over the country. That might seem strange to us these days. After all, when was the last time anyone you know sat down to read a newspaper, let alone went to the newspaper to read a political essay in it? But at the time, with no TV, radio, or other modern distractions, it was very common. The Federalists published a series of defenses for the Constitution using a common pen name between them called Publius. These 85 essays, written mostly by Hamilton and Madison, were later collected and published as the Federalist Papers. To this day, they are the best single commentary on what the Constitution actually means, given by the men who actually wrote it. If you want to know most anything about how the Constitution is intended to function, the Federalist Papers are the first place you should check. Well, after the Constitution itself, of course. Consider the right to bear arms. There has been much debate over whether the Second Amendment means that individual people have a right to own guns or whether it was just the state militia. Well, check out Federalist number 46, where James Madison, the father of the Constitution himself, makes it clear that it protects the rights of individual people to own weapons in order to overthrow a tyrannical government if necessary. Does that sound crazy? Well, consider. It's exactly what the Americans themselves had just finished doing. Obviously, the Federalists won the argument in the end, but don't be tempted to write off the Anti-Federalists. They also made a number of very important and timely observations in their essays. They were concerned most about the massive increase in power in the central government, the absence of certain checks and balances, and of the lack of a Bill of Rights. Some of their predictions have been eerily accurate. For example, they warned that there were very few practical checks and balances on the Supreme Court. Hamilton and Madison derisively replied that none were needed because the court was, quote, the weakest branch of government, and therefore there was nothing to fear. Well, starting in the 1800s and building steadily since, the Supreme Court has gradually accumulated a massive amount of power, to the point that its 9 unelected justices in some ways act like independent rulers of the country, not just deciding whether or not a law is constitutional, but ordering the laws rewritten in specific ways that affect the entire nation. That was something that the founders never intended, and more than a few people argue that it is dangerous to freedom. The Anti-Federalists nailed that one. The Federalists promised that if the Anti-Federalists would get on board and ratify the Constitution, the first order of business would be to pass a Bill of Rights. That might seem to beg the question, why would you not want one to begin with? The answer might surprise you, and it has to do with our understanding of rights and how it has changed in the past 200 years. Today, many people think of rights as a guarantee to something. You have a right to a certain standard of living, or to certain privileges. At the time of the Constitution, however, rights were thought of as freedom from something, specifically government interference. Here you can think of freedom of religion or speech. You have a right to be guaranteed freedom from the central government telling you where you had to pay your tithes or go to church, and freedom from the government interfering with your speech. Now, if we had to list every single thing you have freedom from interference with, we'd never finish the list. You have freedom from the government telling you where to go to college, what car to buy, what books to read, whether or not you go out today, even as we said earlier, what toothpaste to use. The founders would have understood all of those to be part of your rights. Now, James Madison was worried that if we called out 10 or 12 or whatever number of specific rights in a Bill of Rights, it would come to be seen as the only things the government can't do to you, and the government would then start doing all of the others. In Madison's view, you don't just have 10 rights, you have thousands. This has since proved to be a prophetic concern. Today, most people assume that the government can do anything that is not specifically protected in the Bill of Rights. The Bill of Rights itself has become one of the most abused documents in American history. Remember our talk at the beginning about reading what you want into a document. Since the Bill of Rights was passed, thousands of people and movements have attempted to reread and redefine the Bill of Rights to mean whatever it takes to enshrine their own particular agenda. It should make sense. If you can convince people that doing this thing that you want to do is actually mandated in the Bill of Rights, then you can guarantee your agenda will win. And so, they've done some torturous things to it over the years. Just a few case studies. In the First Amendment, we have separation of church and state, right? Don't we? Well, I have a challenge for you. As you're reading, find those words anywhere in the Bill of Rights or in the Constitution itself. Separation of church and state. You won't. Most people believe they're there, but they're not. Why not? Because the modern idea of separation of church and state, where religion is somehow banned from public places and public schools, simply was never there. It was read back onto the First Amendment by a leftist Supreme Court in the 1960s. The First Amendment does prevent the Congress, particularly the Congress, from designating a specific church or denomination for the whole United States. But this wasn't done to create an atheist utopia. It was actually done to protect religion. At the time, several states had officially state-sponsored churches, like the Anglican Church in Virginia and the Congregational Church in Massachusetts. If Congress declared, say, Anglicanism to be the official U.S. religion, then that would conflict with Massachusetts, and vice versa. So the central national government was banned from choosing one brand of Christianity over another. In fact, Christianity as a whole was sponsored and celebrated by the national government consistently into the 20th century, with chaplains appointed to all branches of government, to the armed forces, with calls to national days of prayer, and even Bible instruction inside the public schools when that movement got started. So where did all this modern anti-religious nonsense come from? Well, it's a prime example of kicking the Bill of Rights around. If you redefine the First Amendment to mean what it was never intended to mean, and then you teach that consistently from that perspective, you can change and convince the American people to support your views. The Second Amendment is another excellent example of this trend. It specifically protects the right of individual Americans to own private firearms. Why? Because most of the weapons used in the early parts of the Revolution were privately owned, and the Founding Fathers wanted the American people to be able to do it again if the government ever got tyrannical. The states were supposed to maintain militia forces, and the people were supposed to maintain private firearms so they could use them if called up to serve in the militia in an emergency. Today, though, people who want to pass stricter and stricter gun control laws say that the Second Amendment doesn't apply to individual people, only to the militia. And the National Guard is the modern equivalent. Well, why say that? Because if you can redefine the Second Amendment in such a way that it doesn't protect Americans' rights to own guns, these people have a better chance of taking those guns away. And again, it all gets down to creatively reinterpreting the Constitution and Bill of Rights to say things that they don't. Also, as you're reading, pay attention to the 9th and 10th Amendments. Most people actually don't even know what they are. In fact, they are in theory the most powerful of the amendments because they say that these rights aren't the only rights that the people enjoy, and that any rights not specifically given to the federal government are reserved for the states and the people. So, leaving the Declaration and the right to life aside for a moment by way of example, where in the Constitution does it say anything about abortion? It doesn't. So according to the 9th and 10th Amendments, that is an issue that's supposed to be decided at the state level, not the federal. Where does it say anything about school prayer? It doesn't. So again, that is supposed to be left to the states. That way, if California wants to ban school prayer and if Georgia wants to allow it, both are free to do so. If you don't like one or the other, you're free to move to the place that agrees with you. And that is also one reason why today these amendments are almost completely ignored. Both sides of the political spectrum want to use the government as a bludgeon to force their ideas onto everyone else. It was, and will remain, a controversial set of topics. Once the Constitution had been written and ratified, almost immediately two schools of thought on how to interpret it sprang up. Since then, Americans have tended to occupy one or the other of these two historical positions. Strict constructionism was pioneered by the likes of James Madison and Thomas Jefferson. According to strict construction, the government can only do those things specifically allowed by the Constitution. Therefore, if the Constitution doesn't say anything about it, the government must leave it alone. This is an interpretation that places a premium on personal freedom and was incorporated into the original document by Madison on purpose, who saw it as a built-in Bill of Rights. Where in the Constitution does it say anything about the government regulating free speech? It doesn't, and therefore, according to Madison, it can't. This would result in a much, much smaller government if you think about all the things that the government does that are not specifically spelled out in the Constitution. Loose construction was put forward by Alexander Hamilton. Hamilton believed that the government should be able to do anything that isn't specifically forbidden by the Constitution. Therefore, since the Bill of Rights specifically bans the government from interfering in free speech, he would say that speech was off limits. But what about doing something like, say, establishing a Bank of the United States? It says nothing about that, so he felt free to do it. A strict constructionist would look at that and an issue like the bank and say, where does it say you can start one? While the loose constructionist would say, well, where does it say that I can't? These two positions undergird much of the bickering over the Constitution for the next 100 years or more. The current position, which most people have become acquainted with in colleges and universities today, is really an extreme form of loose constructionism. We might call it no constructionism because it essentially denies that the Constitution means anything at all. This actually began back during the Progressive Era in the early 20th century with a Supreme Court justice named Oliver Wendell Holmes, Jr. Holmes put forward the idea of legal realism, which said, in short, that the Constitution means whatever a majority of the justices on the Supreme Court say it means. I'll say that again. The Constitution means whatever a majority of the justices on the Supreme Court say it means. With this pronouncement, people gave up looking for the original intent of the founders. They focused on what the Supreme Court made out of the Constitution instead. It should sound familiar. Obviously, if the Constitution simply means anything they say, it means nothing in itself. This grew into a larger legal movement called by the impressive name of sociological jurisprudence. In short, this is the idea that since the laws themselves are meaningless, it's the court's job not to follow the law, but to seek a judgment that will result in the greatest amount of good to the largest number of people in the opinion of the court. The trouble is, of course, whose definition of good, and which people are we talking about? It sets up a dangerous game of guessing at right and wrong. Results can vary widely depending on who happens to be playing. And this leads us full circle, back to the original statement about reading and meaning. If the Constitution means nothing in itself, if it is only what the reader makes of it, then it can mean literally anything. There is no original intent, nothing to determine what is true and false. The whole point of a written constitution was to put rock-solid limitations on what the government could do because you could check what the document actually said. People were supposed to be able to look at the written words and know clearly how to proceed. But if those words have no meaning and those limits move back and forth depending on what the justices happen to think, then there are no practical limitations at all. Your rights are guaranteed until someone changes their mind about them, revokes the right, and gets away with it. Of course, this is in direct contradiction to what the founders had in mind for the Constitution, and it heralds the effective death of the Constitution. Not only does the document no longer serve its intended purpose, but if it can be ignored or changed at will, it serves no purpose at all. As we close, there is one more point worth considering. It seems to me that there is a trend in the church to read the Bible as we do the Constitution these days. We come to the text and we look for it to give us what we want to see. We don't search for what is there. When we encounter something we don't like, we either reinterpret it or selectively ignore parts of it, rather than take it for what is there and learn to deal with it. Just consider what's been happening on the debates of homosexuality, LGBTQ, and the Bible in an increasing number of churches. In the end, the answer to both problems is this: we need to learn to read again, meaningfully. We need to search for the truth that authors, or the author, have put into their texts, and not limit ourselves to what we bring them in our own pitifully small imaginations. That is the first step not only to constitutional understanding, but into a larger, wider world.